welcome to Stowe Talks, a podcast designed to support people going through a relationship breakdown and all the challenges this brings. I'm Matthew Taylor.
And I'm Liza Gatchell, family lawyers at Stowe Family Law. And today we're looking at how inheritance is dealt with within a divorce settlement. So this can be quite an issue in some cases, particularly if inheritance has perhaps come in during the marriage and has been used to purchase, a family home, or if it's come in sort of post-separation. So I guess perhaps you can start us off, Matt, by just explaining how the court does view inheritance.
Yeah, so it's a really emotive topic, I think. The starting point is that inheritance... So we talked before in this pod about matrimonial and non-matrimonial assets. Just as a very quick refresher, matrimonial assets are kind of exactly what they say on the tin. They're products of the marriage. They are cash, income, pensions that have arisen as a result of and during the currency of the marriage. Non-matrimonial assets have come from an external source or arose before the marriage or came in after the marriage. And the starting point is that inheritance is going to be non-matrimonial because that's come from another source. It's not a product of the marriage. It's come from one party from their family. However, non-matrimonial assets can be matrimonialized by mingling. And when we talk about mingling, we talk about mixing these assets into the matrimonial assets so they lose their non-matrimonial character. Okay, so that's sort of an important concept here. So using those sort of basic principles, the way that the court treats inheritance is going to depend on a case-by-case basis, as is always the answer really in family law, and anyone who listens to a few of these will pick that up all the time, is the answer is almost always, it depends. So there's a very different approach to an inheritance that was received 15 years ago and used to pay down the mortgage by 50 grand, and an inheritance that was received after the parties separate has been kept in a separate bank account. Because in the former example, the asset's been matrimonialized, it's been mingled, and then it's gone into the most family asset. The family home is the most, it's like this sacrosanct thing, isn't it? So I think it's quite difficult to argue in those circumstances that the inheritance should be recognised and being ring-fenced. In the latter example, if it's been received after the marriage as inheritance, it's clearly non-matrimonial, and it's not been mingled, it's been kept separate, it's much easier to say it should be ring-fenced. And the impact of this is that matrimonial assets can be shared, the sharing principles, so starting point of add up and divide by 2, but non-matrimonial assets can't be shared, they can only be invaded to meet needs. So the court can have regard to them, can look at them, and can use some of them, but there's not an automatic right to 50-50. So that was quite a sort of long explanation of stuff, but maybe you want to talk in a little bit more detail, a bit more nuance, Lisa, about the really tricky emotive stuff, which is I had an inheritance from my dad a few years ago, and that's gone into the house, and now we're divorcing, and you're telling me it's going to be 50-50, but my ex, his parents are still alive, and he's going to get inheritance in the future. I mean, what do you think about that when that comes up?
Yeah, it is really tricky. It's particularly tricky because they usually do have those circumstances where one party's parents have already passed or died, and the inheritance is already there. And then the other party might have parents that are actually very wealthy, but are, potentially have another 20, 30 years, if you like, to live. So their inheritance, they know that there is a future inheritance potentially there. I suppose when we're talking about inheritance, it's perhaps... Let's talk about those future inheritances. The reality is that the court is not going to look at an inheritance unless it's crystallised. So that would usually mean the party has died. So the party has died, and therefore we can look at, what they've left to somebody within their will. We're not going to be looking at the potential inheritance that's going to come in because there are various things that can happen. So, for example, there could be a falling out between your ex-partner and their parents, in which case wills can be changed. And if we factored that into the divorce and then they get nothing, obviously that can also be viewed as very unfair. So we do have to be looking at inheritances. We really are talking about ones that have crystallised. So the party has already died and that inheritance is either going through probate or has been received by the party. So when we're looking then at the example you just gave, I think the difficulty comes in that quite often between parties, the money is used for the family home. And the family home is like the pinnacle of matrimonial assets. And ordinarily the family home is shared. So unless you've done some sort of agreement, so perhaps a postnuptial agreement or a declaration of trust or something to show that the intention when that money was put into the family home was that actually it would go back to the person, if you like. And let's be honest, very, very rarely does that even occur to anybody when they're doing these things. Then the fact that an inheritance has been received during the marriage and it's put into the family home means that it's almost always matrimonialized, and it's very, very difficult to run arguments that should be ring fenced or moved out of the equation. That's slightly different to if the inheritance has come in during the marriage, and it may be that inheritance has come in 15, 20, 30 years ago, but it's been kept in a separate bank account, or it was used to purchase a rental property in one party's sole name. And I think in those circumstances, you have more arguments to be able to put forward as far as those assets being ring fenced, but it's very, very difficult if that money's being put into the family home. So people really need to think about if the inheritance is coming in, what they're going to be doing with it, and the impact that potentially has.
Yeah, I think that's exactly it. It's the mingling that makes the difference. That's what changes it from being non-matrimonial to matrimonial. So, I mean, you mentioned postnups just then. Should maybe talk about some practical advice for people who are thinking that there is an inheritance potentially coming in. And this part also applies to lifetime gifts as well, doesn't it? So, if you are, there are really two ways, I think, to protect inheritance in a sort of a legal way, other than just the sort of manual thing of keeping it in a separate bank account, like you said, Lisa. And that's postnups and also trusts, and they often work together. So any asset that's passed from a non-matrimonial source, if you want to try and ring fence that, then entering into a postnuptial agreement is a really important thing. The downside of postnup is it requires the consent of your spouse, and if they're not going to consent to it, you can't force it. Short of getting divorced before the inheritance arises, but that's a pretty extreme step in most cases. They're probably more common with the lifetime gifts, because sometimes parents will say, I'm going to give this money, but this money is conditional on there being a postnup. They may say, however, I'm going to write you out the will unless it's a postnup. So, it depends on the family dynamics about how that works. But a postnuptial agreement, if properly done, if there's been disclosure, if there's been independent legal advice, if it's fair, can quite easily say that, this anticipated inheritance remains one party's separate property and isn't available for sharing. The court can still overreach it to meet needs, but done at a much lesser level than without a postnup. And every prenuptial agreement, every postnuptial agreement that we draft, and I've been working on a prenup this week, and included in that is a very clear statement that anything that is inherited in the future by either party from their parents will be separate property and therefore not available for sharing. So that's one step. The other step is to put the money in trust. And that depends on how you're going to use the inheritance. That might tie things up more than you actively want to. But if you have monies in trust, and those trusts are non-nuptial, so they've not been created to support the marriage, and the other spouse is not a beneficiary under the trust, and it's a very clear sort of statement that the intention of the trust is not to support the marriage, then that's another way to kind of guard against claims against inheritance on divorce. I think that that's probably the best steps that can be taken to kind of deal with that. But if the inheritance falls in and then you get divorced, then you in the absence of those agreements that you can't always force or don't always work, you are subject to the vagaries of the court and an assessment of mingling and an assessment of needs, aren't you?
Yeah. And I think the problem is in 90% of the cases that we will deal with where there is an inheritance aspect, the money's come in and it is needed to meet needs. There's not enough there. That if we took the inheritance out and then we did the whole, add together, divide by 2, there's not enough there to rehouse both parties. And therefore the court is going to invade that inheritance anyway, no matter what we've kind of said beforehand or where the money's been put, because, needs will always take precedence.
Yeah. I think your best hope in that is trying to argue that, well, maybe my spouse's needs should be met at a slightly lesser level than mine, because there is this contribution that's come from another source, or contribution to one of the factors in Section 25 of the Matrimonial Causes Act. So you run a contributions argument to say that's got to be reflected in some way, shape or form. is that likely to result in the entire sum coming back to you? I mean, it depends on the figures, but probably not. But might you get some sort of recognition that there has been this contribution from another source? Yes, possibly. But yeah, it's a really tricky area. And you end up with these two emotive positions, which is, how can you be taking this money when it came from my late mother? Which is understandably very emotive. And the contrary position is, hang on, we've lived in this house for years and years and years. How can it not be a 50-50 asset when it's been our family home? And that can be a really difficult square to circle. I can see the arguments on both sides. So, some sort of compromise which reflects to a degree that some of the money's come from an extraneous source, but maybe doesn't do it to the full amount to really cause difficulties for the person who didn't inherit the money. That can be a sensible solution for these.
So that's it for this episode of Stowe Talks. Thanks for listening. If you would like more information on our podcasts, head over to stowtalks.co.uk and please rate, like, share and review this podcast where you can.